Welcome, I'm Russell Alexander. I've been a lawyer here with the team at Russell Alexander Collaborative Family Lawyers for over 20 years. We help families going through separation and divorce. Without further ado, let's get into today's topic. Word nerd alert. Was it nature or consequences, or else nature and consequences? Lawyers are known for missing words and hanging on legal technicalities. For those of you who like precision in language, here's a little family law word puzzle around the interpretation of the Ontario Family Law Act that might have some people nodding in disagreement or agreement, while others may be left scratching their heads. Under Section 56 sub 4 of the Family Law Act, the court has the potential authority to set aside a domestic contract or a provision in it only if it finds one of three conditions are met. The first two are where the general laws of contract call for the agreement to be set aside, for example, where one party was under a legal incapacity. Two, where a party fails to disclose significant assets or debts that were in place when the domestic contract was formed. The third possibility is found in Section 56 sub 4b, is where a party did not understand the nature or consequences of the domestic contract. Importantly, this provision uses the word or between nature and consequences. That word or was the crux of an appeal argument in a case called Faiello. The spouses had been together 26 years and formally married for 18 of them. Under the separation agreement, which had been reached with the help of a lawyer, partly chosen by the father, the parties had negotiated a give and take on various issues. However, within the year of separating, the father stopped abiding by his obligations under the separation agreement, and instead went to court to challenge its essential validity as a whole. Among other things, he asked that the court set aside the contract pursuant to the authority granted under Section 56 sub 4 of the Family Law Act. At trial, the judge decided to, before we get to that, if you're enjoying this video, find it helpful, give us a thumbs up or leave a comment below. A trial was appealed to the Court of Appeal, where the father argued the trial had applied the wrong test. The trial judge, rather than assess whether the husband did not understand the nature or consequences of the agreement, the trial judge's reasons have referred in a few spots to the phrase nature and consequences, an apparent conjunctive test. In other words, according to the father, the Family Law Act stated that the agreement could be set aside if it was found he had not understood either the nature of the agreement or the consequences of the agreement, not both. But the trial judge erred by assessing the facts if there was an and, quote, the semantic argument did not persuade the Court of Appeal. As the Court of Appeal conceded, the trial judge's reasons did not contain passages that included the word and, rather or, between the two words. But so did the husband's own materials that he filed with the court. While the nature and consequences was technically incorrect, the insertion of the word and had been a causal misnomer. It was not truly substantive in nature. Indeed, the trial judge was clearly alive to the different meanings inherent in the words nature and consequences. And the upshot of the resulting ruling showed that the judge's substantive focus was on the husband's mental or emotional state at the time the agreement was signed. In the judge's own words, there had been an evaluation of whether the father understood the fundamental nature of the agreement and the effect or impact of the terms of the agreement. The Court of Appeal added In the paragraph, the trial judge explicitly articulates the very definitions the father now argues must be considered. The trial judge's use of the phrase nature and consequences was entirely understandable in articulating that he was not persuaded that the father had failed to understand either of these. The Court of Appeal saw no merit in the father's argument on this point. My head scratching is yours. To learn more about this case, read the full article in the description below. Once again, leave your thoughts and comments. It seems like only lawyers would argue over things like this, but it went to the Court of Appeal. If you found the video helpful, give us a thumbs up. And then once again, you can subscribe to our channel by hitting the bell icon to get notification every time we upload a new video. Thank you for watching.